Okay, today we're going to discuss the federal court system. And it's important that we start out by talking about the fact that the federal court system is an important component of our government system. When you look at the three branches of government, you have the legislative branch that makes the laws, you have the executive branch that enforces the laws, and you have the court system that interprets the law. So judicial review is the power of the court to look at any government action and determine whether or not it's constitutional. That is the driving force behind judicial power in our country. So let's look at where the courts have their jurisdiction. So you have three different categories of jurisdiction that we'll talk about. There's original. Original jurisdiction refers to where a case has to start. Most cases in the federal level start at the district level. And we're going to talk about the three levels of the courts in just a second. So where does a case start? Very few cases have their original jurisdiction in the Supreme Court. What that means is that most of the Supreme Court caseload comes from the next level of jurisdiction, which is appellate jurisdiction. Appellate jurisdiction means that you have jurisdiction over a case by reviewing the decision of a lower court. So we're talking about a higher court reviewing the decision of a lower court, and that creates your appellate jurisdiction. To understand concurrent jurisdiction, you need to first understand that there is a dual court system in our country, that we have a system of federal courts and we have a system of state courts. And sometimes a law or an action violates both state and federal law, which puts the jurisdiction concurrently in the hands of both the state and federal courts. Now, when it comes to power, again, I just mentioned at the top of this discussion that the power of the courts rests in its judicial review. The historic court case of Marbury versus Madison gave to the court the power of judicial review. And with that, they can look at any action of government and determine whether or not it's constitutional. However, there is a limit on that power, and that is the fact that the court's power is what we call passive. That the court cannot reach out and decide an issue. They have to wait for an issue to come before them. So the example I like to use is that Congress tomorrow could pass a bill that outlaws every form of gun ownership in this country. Some would see that as a clear violation of your Second Amendment rights. And the court would be powerless to act on it, even if they knew in their hearts that that was an unconstitutional act. They would be powerless to act until a case came before them where someone had sued because of injustice. And that brings up a key point about who can sue in our country. In our country, you need to have what is called standing in order to sue. You need to have been personally injured or harmed or wronged by an action in order to be given and granted standing in the court's eyes so that you could even bring a lawsuit. So there's a lot of obstacles in the way of a case making it to the courts. Now, who's who in our justice system? You have the Attorney General. He heads up the Justice Department. He's kind of like the lead prosecutor for the country. And under him are all the federal prosecutors. So if you commit a crime at the federal level, the Attorney General and all the federal prosecutors will be the ones carrying that case forward. When cases get to the Supreme Court and the United States is involved, the Solicitor General will be representing the United States in that case and defending the government's position. Judges are important when you look at discussing the structure of the court. So what I'm going to do right now is look at the structure of the court. So there are three levels to our court system that we're going to focus on. There are the trial courts, and those are the 94 different districts throughout our country. So each region has their district court, or each state has several district courts. These are where the trials happen. This is where evidence is presented, the prosecutors bring their cases. This is the beginning of our system. Now, next up, you have appellate courts. There are 12 regional circuit courts of appeal that are spread throughout the country. California, we have the Ninth Circuit. Now, these cases, no case can start in the Court of Appeals because their jurisdiction is solely appellate. They have to hear a decision that a lower court has put forth, and they will determine whether or not the decision was correct or if it needs to be modified. At the top of our system is the United States Supreme Court. There is no action after the Supreme Court. Their decision is final. And it's important to note that the Constitution only mentions the United States Supreme Court. All the other courts that are seen here, all the lower courts, are created and maintained by Congress. So that's a key power we'll talk about later.